And today, the Supreme Court has answered that question by a vote of 6-3.
The U.S. Supreme Court has just issued a major ruling.
Major Second Amendment case.
Major Supreme Court ruling.
We are watching the total collapse of a nearly century-old federal gun regulation system. We are talking about suppressors. We are talking about short-barreled rifles. We are talking about the National Firearms Act, the NFA, and the legal battles that are threatening to tear it down piece by piece. The tax has been zeroed out. That was the first domino. Now, the rest of the structure, the registration, the waiting periods, the whole bureaucracy, it's supposed to fall next. That is the plan. But the Department of Justice, even under the current administration, is not going gently into that good night. Not at all. In a critical nationwide challenge, the DOJ just filed another brief defending the NFA tooth and nail. But here's the problem. The procedural landmine they just stepped on. The plaintiffs, the groups trying to dismantle the NFA, have caught the DOJ trying to cheat. They are accused of actively breaking court rules, attempting to sneak in a brand new critical piece of evidence at the 11th hour to save a crumbling defense. This isn't just about the Second Amendment anymore. This is about government attorneys playing fast and loose with the rules of law, and the plaintiffs are demanding the court hold them accountable. Let's break down exactly what just developed in this monumental case, who is fighting whom, and why the DOJ's alleged procedural malpractice could actually be the blow that collapses the entire NFA structure. To understand the current legal war, you have to rewind a little. For decades, the entire legal basis of the National Firearms Act of 1934, which regulates machine guns, short-barreled rifles, suppressors, and destructive devices, was not the Second Amendment. It wasn't purely public safety. It was the government's power to tax. The infamous $200 tax stamp, levied on every transfer and every making of an NFA item, was the key. Since Congress has the power to tax, the Supreme Court has historically allowed Congress massive latitude in regulating the things they tax. The registration requirement, the background checks, they were all justified as necessary tools to enforce the collection of that $200 tax. It was a tax collection scheme, masquerading as a public safety law. That was the shaky foundation. Then, everything changed. Through the passage of H.R. 1, that massive piece of legislation, Congress dramatically altered the landscape. They reduced the NFA tax stamp on specific items, suppressors, SBRs, and short-barreled shotguns, from the historic $200 down to absolutely $0. That zero is the constitutional poison pill. Once that tax was eliminated, Second Amendment advocacy groups and concerned plaintiffs realized the legal architecture of the NFA was fundamentally exposed. If the purpose of registration and transfer requirements was to enforce the tax, and the tax is now zero, what is the remaining legal or constitutional justification for the bureaucracy? The answer, the plaintiffs argue, is none. It's vapor. This is the core argument of the Censor Shop Challenge against the ATF, a coalition of major players, including Gun Owners of America, the Firearms Research and Commerce Coalition, FRAC, Palmetto State Armory, and Censor Co., joined forces to file suit. Their argument is clean, simple, and devastatingly precise. $0 tax means the constitutional basis under Congress's taxing power evaporates. Therefore, the remaining restrictions, the registration, the waiting times, the entire bureaucratic nightmare, exceed the enumerated powers granted to Congress. Multiple states even jumped into this lawsuit, aligning themselves with the plaintiffs, recognizing the profound federal overreach. Now, both sides recognized that this case wasn't going to drag through years of trial discovery. It's a pure question of law. So they filed cross motions for summary judgment. This is the legal equivalent of saying, Judge, we don't need a jury, we don't need testimony, just look at the facts and the law we've presented and rule in our favor immediately. The DOJ had to defend the indefensible. They had two main lines of attack. First, they scrambled to find some vestige of tax power remaining. The argument they landed on was weak, the Special Occupational Tax, or SOT. This is the annual tax levied on manufacturers, dealers, and importers of NFA items, not on the general public. The DOJ claimed that the general NFA registration system is part of a web of regulation that still helps enforce the SOT against those businesses. It's a desperate attempt to connect a tiny niche business tax to a massive nationwide registry of individual consumer items. Second, the DOJ fell back to the most common federal defense when the taxing power fails, the Commerce Clause. They argued that the NFA is independently valid because it regulates items that cross state lines. They even went a step further, echoing decades of broad federal arguments, claiming that even purely intrastate activity, like making a suppressor in your basement for personal use, must be regulated. Why? Because unregulated local markets, they claimed, would create a gaping, dangerous hole in the federal regulatory scheme. This is the classic argument the federal government uses to regulate everything from wheat, grown on private property, to local gun manufacture. And finally, as a last resort, the DOJ addressed the Second Amendment head-on. They relied on older precedents, arguing that items like suppressors and short-barreled rifles fall outside the core protections of the Second Amendment, meaning the NFA restrictions are constitutionally permissible even if the tax and commerce arguments are shaky. This, coming from the government, is the ultimate concession. They are admitting their primary legal justification is weak, so they have to say, even if we are wrong on the law, it doesn't violate your rights anyway. That was their initial defense, and then the plaintiffs responded, tearing those arguments to shreds. And that is when the alleged governmental trickery began. If you're finding this analysis helpful, please take a second to like this video and subscribe to Law Advisor. It helps us keep these deep dives coming. Now, back to the case. The process is simple. The plaintiffs make their case, the DOJ responds, and then the plaintiffs get a chance to reply to that response. The DOJ gets a final, last word reply brief. That reply brief is strictly limited. It is meant for rebuttal, not for introducing brand new legal concepts or, critically, new facts and evidence that the opposing side has never seen before. This is exactly what the DOJ is accused of doing. In their final reply brief, the Department of Justice attached a brand new, never-before-seen, sworn declaration from the ATF. This declaration attempts to manufacture evidence to support their dying taxing argument. The ATF official claimed, suddenly, that the NFA registration system is still absolutely necessary because the ATF denies hundreds of applications every year due to SOT issues related to the dealer-manufacturer tax, not the consumer tax. The plaintiffs were immediately on this. They slammed the court with a motion to strike that evidence entirely. This is a massive procedural screw-up on the government's part, or, perhaps more accurately, a calculated risk that failed. The rules in the Northern District of Texas are clear. You cannot introduce new evidence at the reply stage without express advance permission from the court. The DOJ did not get that permission. They simply tried to slip this affidavit into the final submission, hoping to sneak a new factual defense past the judge. They were attempting to plug the most glaring hole in their defense, the lack of connection between registration and tax enforcement, after seeing exactly how effectively the plaintiffs had exposed that weakness. In legal terms, this is what we call taking a second bite at the apple. They tried to win with their original facts. When that looked insufficient, they tried to create new facts after the clock had run out. This is not good faith litigation. The plaintiffs, quite rightly, are furious. They point out that the DOJ had months to gather and submit all the evidence they needed to support their legal theories in the initial briefs. They even filed one affidavit originally. This second, surprise declaration is a desperate, late-game attempt to fix a weak argument. The court cannot allow this. Allowing the government to bend the procedural rules gives them an unfair advantage against private citizens who must adhere strictly to every rule. The rules of the game matter, especially when fundamental rights are on the line. The plaintiffs have asked the court to either strike the new ATF declaration entirely, pretending it never existed, or at the very least, grant the plaintiffs the right to file an immediate surreply, giving them a chance to formally respond to the new evidence the government tried to ambush them with. But wait, let's look at that again. Even if the evidence is allowed, the numbers the ATF provided don't actually help the government's case. They actively support the plaintiffs' claims. The DOJ's new declaration claims that in a recent fiscal year, the ATF denied approximately 691 applications related to the SOT, the Special Occupational Dealer Tax. That sounds like a lot, right? Hundreds of applications denied. It sounds necessary, but context is everything. The plaintiffs pointed out that in that same year, the ATF processed more than 1 million total NFA transfers. Do the math on that. 691 denials out of 1 million transfers. That translates to a minuscule denial rate of approximately 0.03%. If only 0.03% of all transfers are denied due to SOT issues, how can the government argue that a massive, pervasive, time-consuming, nationwide registration and transfer system is necessary to police that vanishingly small number of dealer violations? The numbers show the registration system is overwhelmingly disconnected from the purpose of tax collection. It is regulatory overkill. It is a massive burden imposed on 2 million citizens to catch less than 700 dealer errors. The ATF's own declaration, the one the government tried to sneak in, inadvertently provides the most powerful statistical evidence yet to support the plaintiff's core argument. The registration requirement serves no meaningful tax collection purpose. Now that the consumer tax is zero, the plaintiffs also attacked the underlying premise of the data. They argued that the declaration relies on past practices established when the law still featured the hefty $200 tax. But we are in a new era now. We are under the $0 tax system. The government's brief offered absolutely no explanation for why those outdated procedures and that old data remain relevant or necessary under the current structure. They are relying on old evidence under the old system, hoping the court doesn't notice the foundational shift that occurred when Congress eliminated the tax. In short, the plaintiffs argue that the DOJ attempted a sneaky legal maneuver, violated court procedures, and even if they had succeeded, the evidence they presented is statistically irrelevant and fails to fix their core constitutional problem. The DOJ's Hail Mary pass has turned into a procedural own goal. So, where does this leave us in this fight? We have a $0 tax on suppressors and SBRs. The lawsuit is moving aggressively to dismantle the registration and transfer requirements. And the government, specifically the DOJ, is actively defending the remaining restrictions, arguing that the NFA is somehow still valid under the minor SOT tax and the broadly interpreted Commerce Clause. Now, a crucial procedural fight is underway that could determine the momentum of the entire case. Did the Trump DOJ, and remember, this defense was initiated under the Trump administration and continues now, violate court rules by trying to sneak in evidence after seeing how weak their initial arguments were? The government tried to bolster their position. They got caught. And now it is up to the federal judge to decide whether to simply ignore the new declaration, thereby weakening the government's case considerably, or to allow the plaintiffs to respond, effectively giving them a chance to tear apart this new evidence point by point. This case is truly a unique challenge, forcing the court to grapple with the limits of congressional power. It is not just about the Second Amendment. It is about the integrity of the Constitution's enumerated powers, specifically the power to tax, and whether the NFA can legally survive now that its foundational tax element has been removed. The government, in its rush to defend the status quo, displayed poor judgment and arguably poor faith by attempting to circumvent standard procedural rules. The plaintiffs are not letting this trickery stand, pressing the court to remind the DOJ that they must play by the rules just like everyone else. The government does not get to play fast and loose just because they are defending a cherished piece of federal legislation. This is where the nationwide NFA challenge stands right now. The DOJ continues its desperate fight to preserve the status quo. The plaintiffs continue to push back on constitutional grounds. And now they have a powerful procedural complaint to leverage. The court must decide whether to strike the DOJ's new evidence, or at the very least, allow the plaintiffs another round of briefing to respond to what was just submitted. Either outcome puts the DOJ on the back foot. If the evidence is struck, their case relies solely on the weak Commerce Clause theory. If the plaintiffs are allowed to respond, they will surely use the ATF's own 0.03% statistic to utterly annihilate the argument that registration is needed for tax enforcement. This critical lawsuit is moving toward its climax, attempting to leverage the $0 tax into a total repeal of the remaining NFA restrictions on specific items. As this develops, and as the court rules on this procedural drama, Law Advisor will continue to bring you the full breakdown. Thanks for watching, and don't forget to like and subscribe for more legal breakdowns. And remember, stay safe, stay smart, and never forget, knowledge is the ultimate defense. I'll see you in the next one.